Hello, this is Professor Victor Lopez, and today I would like to present a short presentation on a paper that I'm going to be presenting later on this month to the Northeast Academy of Legal Studies and Business at their annual conference. Uh, this is a paper that I currently have out for review, and it is titled When Legal Systems Clash, Why Foreign-Born Residents Fall Prey to Unscrupulous Notaries Public, and What Can Be Done to Prevent It. In civil law jurisdictions, unlike in the United States, notaries public in general are highly trained lawyers who must undergo rigorous training and pass competitive exams in order to qualify as notaries. By contrast, in the United States, notaries are generally required only to be 18 years of age and either high school graduates or possessing a high school equivalency, residents of the state in which they seek to become a notary, and have clean criminal records. That's about it. Only 10 states require any training at all. And when training is required for someone to become a notary, it's typically between 3 and 6 hours in duration, certainly not comprehensive by any stretch of the imagination. And only 13 states require an exam before someone can become a notary. And of those states who require the exam, it's generally about an hour in duration. Again, not particularly difficult exam to prepare for, and certainly not a comprehensive exam either. Notarial fraud is a real problem in the United States. Foreign-born individuals in the U.S. are easy prey for unscrupulous notaries public precisely because the assumptions that they make about the powers of a notary public and their training and experience are very different in the countries from which they hail rather than in the United States. Individuals that come from countries outside of the United States that are civil law jurisdictions, which is by far the most prevalent legal system around the world. Most countries follow civil law rather than the British-based common law system that the United States and former British colonies generally adopt. It's by no means just a problem for Mexican immigrants, even though if you pay attention to the popular media to the extent that it's ever covered at all, uh, the problem of notarial fraud is almost always focused on its effect on Mexican American populations, both legal and illegal immigrants from Mexico who are preyed upon by unscrupulous notaries public. But the problem is much, much broader than that. In fact, it affects immigrants from all corners of the world, from the world dominant civil law system, uh, which is prevalent in the vast majority of nations around the world. In doing my research for this paper, I surveyed all 50 states, and I also surveyed Washington, D.C., and all the U.S. territories. And the details are contained in my paper, which is a little over 11,000 words, in in a significant amount of detail. But there are some patterns that emerge that can be examined rather briefly in terms of the significant differences between the United States and the rest of the world when it comes to the powers and training of notaries public. United States notaries' powers are very limited to such, largely ministerial acts such as administering oaths, witnessing or attesting the validity of signatures, and acknowledging the validity of instruments. And again, some similar relatively straightforward powers that they are provided in the various states. Former French and Spanish possessions, such as Louisiana, Puerto Rico, and Florida, still have some vestiges of their original civil law roots, and notaries in those jurisdictions can have significantly different powers. For instance, in Puerto Rico, notaries have to be lawyers, uh, very similar to the requirements in just about the rest of the world. And in Florida, there are both civil law and common law notaries, with civil law notaries also being required to be attorneys and having very, very different powers and very different training requirements than non lawyer attorneys. Forgive me, non lawyer notaries public, such as the common law notaries, which are pretty much the same powers as just about everywhere else throughout the United States. In contrast, the powers of notaries public in civil law jurisdictions are very, very different. My research included sample civil law jurisdictions in Latin America, including North America, basically Mexico, and Central and South American countries, as well as European countries and African countries and countries in Asia. It was much more difficult for me to do research about Africa in particular, and also Asia and many European countries, because information about these is generally not included in the legal research databases that are the bread and butter of my research, unless I can do research off country, which unfortunately, although it was the original intent for this paper, I was unable to do due to the travel restrictions due to COVID-19. Having access to both LexisNexis and Westlaw, there are still very few foreign jurisdictions for which it is easy to find, or even possible to find, primary sources of law, such as statutes and regulations, which are, again, in the absence of being able to find them in the legal databases, the only other option is to find information that is available online from countries or consulates that provide such information. And unfortunately, in many cases, in most cases, this is not available in English. They have not been translated, and in many cases, it's not available at all, as was the case in many of the African countries that I would have liked to have included in my research, as opposed to just a handful that I could get information on. I had little difficulty with Spanish speaking nations, and Mexico, Central America, South America, and obviously Spain, as Spanish is my native tongue. And I did a lot of translating from the available databases available online in Spanish. But when it came to other languages, I obviously had to rely on what was readily available online, and unfortunately, that's not the case for the vast majority of the world's nations. Nevertheless, I was able to get a good cross section of information from European, African, Asian, and North and South American countries, and was able to sort of get the common threads that are available in all of these civil law jurisdictions. And they include the following. In all jurisdictions, notaries public must be attorneys. And not just attorneys, but attorneys that are subject to additional training and or internship or practicum experience before before they are able to become notaries public. They also need to have significant experience working as attorneys, and in some cases under a notary public for a period of time before they can get their own commissions. There are competitive examinations that these attorneys have to pass in order to get their commissions. And appointments are limited. Unlike in the United States, you're not going to have a very large number of individuals who can become notaries public. Even those that meet all of the requirements are generally limited by a system that imposes strict limits on not only who can become a notary, but how many notaries the country can support. And citizenship is a requirement for notaries in all of the countries that I examined. In some cases, must be natural born citizens. In others, they can be citizens either through going through the process of obtaining citizenship if they were not born in the country. So they can be naturalized or foreign born. In some cases, they must be born in the country in order to qualify. And also, in many cases, there is an age limitation, 25 or 30 years of age minimum in order to become a notary. Some countries also limit the age after which a notary can practice. It's not unusual to have limitations of 60 or 65 years of age, after which a notary can no longer continue to practice their profession. And good moral character is required of civil law notaries, just as it is in the United States. What constitutes good moral character can vary, as also it does in the United States, but in general, individuals who have been convicted of serious crimes, to wit, felonies or crimes of moral turpitude, will not be able to ever become notaries in foreign jurisdictions, and usually the same in the United States as well. Powers of civil law notaries are, again, very different from non-lawyer notaries in the United States. They are all attorneys with full power to practice law, in addition to additional specific powers that are granted only to notaries who have obtained their commission. They can charge significant fees for services, unlike U.S. notaries that typically can only charge nominal fees such as $2 or $3, in some cases less, for the ministerial acts that they are authorized to administer. Notaries also have unique powers to draft and acknowledge the legality of certain types of documents that require notarization. So they're not simply saying that the document is genuine, they are in fact able to draft documents and draft deeds and contracts and perform other acts such as representing individuals before tribunals, and also uncontested divorce where that is available, on and on and on, creating valid contracts and so forth. They are full-fledged attorneys, or what frankly we should really consider attorneys plus, attorneys with a significant additional and experience. Notarial fraud in the United States occurs when foreign-born legal and illegal residents mistakenly approach a notary or are approached by a non-lawyer notary in the United States who agrees to provide services and representation that they are not authorized to provide. Unfortunately, for most foreign-born individuals, and not just individuals from Mexico and parts south, the word notary especially if it is written in advertisements or in signage in their own language, such as Notario Público, or the equivalent title for a notary abroad, has a very specific meaning, and therefore, when they see the signage or when they see an advertisement for a notary public, that is where they will go when they have uh, legal issues that they need resolved, including issues relating to immigration and the filling out of paperwork uh, for dealing with any government office and or representation before government offices and or the courts. They're easy prey for unscrupulous notaries public because they approach these individuals with the belief that they're not just lawyers, but highly trained lawyers who can best represent their interests. And again, most foreign born individuals, whether they are here as visitors or as business travelers or as legal or illegal immigrants, are unaware of the limitations of U.S. notaries. Nobody tells them that a notary is not the same here as it is in the country from which they came, or any other country that they may be familiar with in the region, which follows the civil law and requires notaries to be highly trained and highly skilled lawyers. There's clearly legislation required to prevent notarial fraud. Some states have enacted useful legislation, among them Colorado is a good example. Colorado requires disclosures by non-lawyer notaries in broadcast media and signage to the effect that they are not authorized to give legal advice, to draft legal documents, to practice law, to act as immigration consultants, or to represent persons in immigration-related matters or hearings. This, at a minimum, should be required by every state. And there should be specific legislation addressing notaries public who advertise in foreign languages, because that is even more misleading for the individuals that they target. In the absence of congressional legislation, again, all states at a minimum should adopt similar legislation to protect these individuals in their borders. States should also impose heavy fines and criminal penalties to discourage notarial fraud and actively prosecute violators. It does no good that every state has unauthorized practice of law rules if these are not actively prosecuted. And having, as a consequence of engaging in notarial fraud, uh, a civil fine of $50 to $500, is not very much of a disincentive for individuals who are only authorized to charge a couple of dollars for the ministerial tasks that they actually have the power to execute, and can charge hundreds, thousands, or even tens of thousands of dollars to clients who mistakenly turn to them in the belief that they're full-fledged attorneys and who will be able to help them effectively with their problems, be they immigration related, as they often are, or be they related to any other civil or criminal concern that requires the intervention of an attorney. Nominal fines are not going to make a difference, as simple as that. A training of notaries should also include, in every state, including in states that don't require formal training, some type of information being conveyed to individuals who are being accepted into the roles of notaries public, of what constitutes the practice of law and the criminal and civil sanctions that accompany the unlicensed practice of law in every state. In some cases, it is possible that there are perfectly honest and honorable notaries public that are violating the law simply because they're not aware that what they are doing is illegal. When they are attempting in good faith, I would assume in at least some instances, to assist clients with issues that they're being asked to help with. The media, finally, has a major role to play, especially foreign language media that should actively participate through public service announcements and through coverage in news programs and in news magazine programs to disseminate information about the problem of notarial fraud and educate the public, the public that may not be conversant with English, on the inability of non-lawyer notaries to give legal advice, representation, or otherwise engage in the practice of law. Finally, it must be recognized that notarial fraud affects foreign-born visitors and both legal and illegal residents from all over the world, not just Mexico and Latin America, as is often portrayed the few times that the topic is actually brought up in a news program or otherwise in the popular media. Education and active prosecution of unlicensed practice of law are essential to protect a very vulnerable segment of our population. States need to be proactive in protecting all citizens from such fraud. And Congress should, at a minimum, consider legislation criminalizing non-lawyer notaries who provide immigration advice and representation, since this is a major problem, especially these days, with the large numbers of undocumented foreigners who are entering the United States seeking either asylum or seeking to legalize their status. It's a huge problem, especially in border states, but broadly speaking, it is a problem everywhere in the United States where there are residents who visit on a temporary basis or foreign-born legal or illegal residents who settle in the state and are in need of protecting against those who would use their lack of knowledge about U.S. law and U.S. notarial practices against them. That ends my presentation, and thank you very much for listening. Take care.